I'm so excited to bring you today's episode with a panel of expert guests. Jonathan Galea, lawyer and chief executive officer of BCAS Solutions, an advisory firm out of Malta. William O'Rourke, co-founder and partner of ORWL Avocats in France. Francesco Patti, professor of private law at the University Bocconi in Italy. Alexandru Stănescu, partner of SLV Legal in Romania. And Marina Markizic, co-founder and executive director of the European Crypto Initiative out of Belgium. Now, as you noted in the title, this is a series on the EU's Markets in Crypto Assets regulatory framework to be adopted and implemented in the EU over the next year. Now, we're going to be going down the rabbit hole on MiCA because it is a 380-page regulation. I wouldn't call it a light regime. But as Marina notes in the episode, there really isn't enough attention on MiCA. And EU stands to be one of the few jurisdictions that is providing regulatory clarity designed to accommodate the long-term potential for digital assets. It's also not a regime without its imperfections, but the EU's approach is a forward-looking approach that is far ahead of where the US's approach is, which is currently regulation by enforcement, and really in many ways short-sighted. It's being politicized by certain members of Congress. Maybe now there might be some justification for some of that politicization because people want answers after post-FTX and even DCG, but it's still fundamentally about the technology. Again, putting all that aside, this episode, why is MiCA important? What is the scope of MiCA? How are covered crypto assets defined? And we also, in this, we discussed the US's approach, much like I just referred to. But this is why it's so critical to do this now. The US itself has not led in implementing thoughtful digital assets regulation. And honestly, other countries in the world have also failed in this regards. And so for the US, if it seeks to improve the cross-Atlantic market with the EU, it needs to really take account of MiCA with regards to any legislative efforts regarding digital assets going forward. For consistency. In the meantime, the EU simply provides more regulatory stability for builders in the digital asset space. Now, in subsequent panel discussions, we'll be breaking down digital asset issuances and associated obligations of issuers, the definition of an obligation of crypto asset services providers, also known as CASPs, under the MiCA's regime, the role of ESMA, the interplay of MiCA and MEV, minor or maximal extractable value, how MiCA regulates market abuse, security, and fraud, and all that in the aftermath of FTX, and also considering how MiCA interacts with other EU regulations. Now, this is a great episode, and it's truly going to be a unique panel series. If you have any questions or comments you want to share, you want us to cover things in subsequent episodes or delve deeper, you can email me at eric@hesslegalcounsel.com, or you can DM me on Twitter at Hess_legal on Twitter. Lastly, following this episode and after 100 episodes, I suddenly have the realization that I am consistently trying to talk faster than I'm thinking, and not always happy with the results of my own speaking during these podcasts. Oddly, this is a problem that only occurs to me in podcasting, and I suddenly realized that after over 100 episodes on the encrypted economy, it may really be the result of the fact that the podcasts that I take in, and I do take in a lot, I consistently do at 2.5 times or more speed, sometimes 3.5. And I'm not kidding. Members of my household or anybody who's near me when I turn on my podcast before it goes into my ears often look at me like I'm from another planet. Like, how do you listen to it at that speed? But I've trained myself. But I think when I shift into this mode, I'm still trying to mentally go at a faster speed just because I honestly don't recall, after hundreds of hours listening to others' podcasts, I really don't recall ever having listened to a podcast at normal speed. So at any rate, with that realization, I am going to try to slow down and possibly formulate my thoughts a little more slowly and clearly in the future during the episode. It's not a takedown of anything I've done today, but I am looking to improve, and I think that's a clear avenue for improvement in the new year. And now that I'm at 3 digits for my podcast. So anyway, I appreciate your patience. I appreciate your support. And I think you're really going to enjoy this series and a lot of things to come in 2023. Welcome to The Encrypted Economy, a podcast exploring the business, laws, regulation, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel, and your host. Join me on this journey, exploring the reach of these transformative technologies. On this episode of The Encrypted Economy, I am super excited to have an esteemed panel of experts on MiCA from the EU. Rather than me introduce everybody individually, we'll start off with Marina. Please introduce yourself to the group, and we'll go through the rest of the names on the call.
Hi, everyone. Very excited to be here, and thank you so much for the invitation. My name is Marina, and I'm the founder of the European Crypto Initiative, which is a non-profit that is aiming at a better regulation of crypto assets in the European Union. So we've been working with the European Union institutions for the last 2 years, discussing MiCA and also trying to educate regulators in terms of cryptocurrency, blockchain in general, and everything that is connected to the scope of what MiCA is today.
Excellent. Francesco Patti, do you want to introduce yourself?
Yes, I'm an Italian law professor and attorney licensed also in Italy. I teach at the University Bocconi topics related to blockchain technology and smart contracts. At the moment, I'm very focused on MiCA, and I'm working on an academic essay on MiCA. And I've also organized a conference in June concerning this topic. And I'm happy to discuss with you like all the legal implications arising from MiCA for the industry.
Excellent. John Galilea, you want to introduce yourself?
Hi, thanks everyone. Great to be here. I'm Jonathan, a lawyer who's been in crypto since 2013. I head BCAS, which is a regulated consultancy firm focused predominantly on the space. We work with centralized exchanges in terms of helping them with regulatory matters, mostly in Europe, as well as with decentralized projects, mostly in DeFi, on matters such as decentralized governance. We've also worked on the framework of Malta, the Virtual Financial Assets Framework, and have also advised the Japanese FSA and various government entities in Serbia. Currently, I'm also part of the technical expert group advising the European Banking Authority on the implementation of transfer of funds regulation.
Excellent. Alexandru Stătănescu.
Hi all, I'm Alexandru Stănescu, coming from Romania, so in a way representing Central Eastern Europe at this roundtable. I'm based in Bucharest. I've been working with crypto for more than 6 years now. I was one of founder of a crypto project back in the days, and now a partner with SLV Legal, a boutique law firm specialized in tech and deep tech. We are working mostly with exchanges, but also Web3 startups, and really happy to see this going forward in terms of European regulations. Happy to discuss with you. I'm also a New York qualified attorney, so we will be helping Eric in creating the passage between Europe and the US, given that we all know that we are in a cross-border world, so most of the projects are international by nature. Thank you.
Excellent. And William O'Rourke.
Yes, hi everyone. Very glad to participate to this long-form podcast with you. So I'm William. I'm the founder of Orwell Law Firm, which is the leading like crypto boutique law firm in Paris. So we advise numbers of regulated and unregulated projects. In regulatory matters, but also in tax and litigation.
Excellent. So why don't we start off? We're obviously going to talk about MiCA. We have a number of sessions to sort of dig into it because it's certainly not a quick topic. But Marina, why not we kick it off with you and to talk about the significance of MiCA for the EU and non-EU digital assets and service providers.
Yes, great. So I'll really start at the beginning. The MiCA was issued as the first draft in September 2020 by the European Commission, but it was a part of the FinTech Action Plan that started in March 2018. So within this action plan, actually, the European Commission wanted to see how the Europe could be fit for the digital age. And of course, a part of it was the digital or crypto assets that we are in a way talking about, and they are regulated by MiCA. So why it is important, I would say, is because it's one of the first overarching regulation, a bespoke regime in the world that regulates crypto assets. And also it's important within the EU because it is the first time that we define crypto asset as a specific asset that has not been defined before, has not been talked before within any of the EU regulations, any legislation. And I think that's quite revolutionary. As we heard before, we're going to discuss what is the difference between the European regulation and the US and maybe some others around the world. But I think that what is very, very important is now, especially when there's a lot of discussion about the US regulating crypto assets, we've seen this discussion from what is a utility token, what is a security token from the beginning. And I think what's very important here is that MiCA in a way defines tokens. So I would say most of the tokens that we know today that might seen as a utility token as a US, I would say definition, there are crypto assets, which are different from the financial, in a way, assets that we know before. So financial instruments before. So I think that is one of the first very, very important things. The second one is actually the thing that happened in the EU since we knew crypto assets and since we knew crypto was that different member states regulated crypto assets in different ways. And some member states, they even haven't regulated crypto assets in any way. So what we have right now in the EU is basically a non-unified approach to regulation, and that happened before MiCA. So now with MiCA, we'll have a unified approach to regulation. MiCA is basically, it's not a directive, is a regulation, which means that is going to be directly applicable to all the member states with this specific text with the draft that we have today. So no need for changes. And I think that's also something that will bring a lot of positive aspects to how we see today and how we approach the whole European Union market. And the other thing is that MiCA in general regulates issuers and also service provider. So MiCA is regulating the European market. Whoever would like to offer services or issue crypto assets in the European Union market, they would need to be compliant with MiCA. And I think this is very important because it's not only for entities that are incorporated in the European Union, but it's also for all the entities that are incorporated around the world, but they would like to access the European Union market. And I would like to stop a little bit here to see if some others might have some other opinions on this topic.
If I may, first of all, thanks a lot for that, Marina, and I fully agree with you that MiCA is a very much needed step in order to harmonize the treatment of crypto assets across the EU. I would also add that over and above what you mentioned about, let's say, the different treatment of, for instance, financial instruments across EU member states, due to the fact that the legislative act regulating financial instruments is a directive, being named for directive rather than a regulation, would also, let's say, potentially inhibit the full harmonization of treatment of crypto assets across the European Union, since there are various member states, such as, for example, Germany, which, for instance, treat all crypto assets as financial instruments. And therefore, I would just add that in order to have the maximum level of harmonization possible, I would say that the next step would also then be to effectively transition from a directive to a regulation when it comes to the markets in financial instruments. Therefore, going from a MiFID to effectively, I would say, an extended MiFIR, which also, of course, lists all the types of financial instruments for which, of course, there would need to be a separate regime treating them in a fully harmonized manner.
what happens in February of next year with, we could talk about Germany. How do we bridge that gap? And even just recently, was it the central bank in France talked about how they wanted to actually now, before the implementation date of MiCA, they want to have a category of digital asset service providers. Sounds very similar to crypto asset service providers, but you tell me, like, how does the harmonization actually take effect, particularly if you have like regulators who are now suggesting to impose new requirements in advance of the implementation?
So maybe
Can I take it one?
Yeah.
Sure.
So, like, I wanted to say that it's true. So, like, from an American perspective, sometimes we speak about European law, but in theory, like, there are a lot of differences between the member states. And as Jonathan pointed out, like, the most dramatic one is the one concerning financial instruments, what is called securities in the US, because there is a different understanding. And so the fear is that once we will have MiCA, there will be a bit of difference with respect to like what is intended as a financial instruments. And I think that we are going to discuss about it when we are going to talk about the tokens. With respect to the broader question, like looking at countries that go in different directions, we've seen like different strategies. For instance, my feeling is that the French strategy was always the one of trying to anticipate a bit the European Union in order to influence the political proceedings at a European level. And so they try a bit to front run in order to, let's say, then influence a bit more the system to show that things work better, or let's say that they are a model, and put France in a particular position. Italy started strong, like with a public consultation in 2019, like wanted to regulate everything immediately, a lot of responses. But then once MiCA started, they basically stopped everything for a while because they were waiting for the European laws to come. And my feeling is that the approach normally is an approach of waiting and seeing. Except for Germany, that made this let's say, identification of service providers with regulations that already existed in Germany. And so, like, if it's a custodian, they applied rules which are very similar to banks. And I have to say, the approach seems a bit, let's say, very rigorous, but it's not absurd, because you can put MiCA in connection to other already existent European laws, and you will see that at least for service providers, there are a lot of similarities. And so that basically these requirements that will be adopted by MiCA are very similar to requirements that already exist, for instance, for financial intermediaries. And so, like, I think that Germany was only a bit stronger in making clear the fact that these rules apply to these service providers, whether other countries basically did not intervene. And so, like, the hope is that MiCA will bring an additional harmonization level with respect to the service providers. I think that there you will really feel the fact that there is a very strong harmonization with respect to the countries, and countries that are different right now, that have different rules, they will have to adapt them to MiCA. What remains really to be seen is how tokens will be handled. And here, I think that an important role will be played by the guidelines that will be enacted by the European authorities, in particular by ESMA. And the key point is understanding, like, when the token is not a security, which I think it's a paramount question that everyone puts. And I'm sorry to say that MiCA does not really indicate clearly how this differentiation should be made.
Alexandre.
If I may, just to follow up, and I'm pretty sure that William also has some interesting stuff to tell us from France, which indeed was one of the pioneers in Europe, together with Malta, at some point together with Estonia. So in terms of regulatory arbitrage, if you want to, we've seen in the last 4 years some different speeds across the European Union, with the countries who were leading the way, Malta, as Francesco was mentioning, France, Germany, and then you had also countries who created a sort of internal availability, or a sort of let's say, more tolerance towards crypto assets and how you're dealing operationally with them, but also countries which had literally no regulation on the topic, like was the case for Romania. So whatever those type of countries incorporated, they were incorporated as part of other European legislation that needed to be enacted, such as the Anti-Money Laundering Directive 5, for example. So you had for the first time there the definition of what's a digital asset, what's a custodian, what is an exchange. So those definitions proved important, at least for lawyers to juggle with all these concepts and put them into a legal interpretation. And again, like in Italy, also in Central Eastern Europe, from discussions with my colleagues, but also in Romania specifically, there was this wait and see when MiCA was starting to move forward in an accelerated way. The Romanian authorities decided that it's better, to follow the European path. Last point here. While for companies from across the world, MiCA with its 308 pages seems quite a sound but also cumbersome regulation. Let's not forget that it provides a lot of opportunities in the fact that once you are licensed in one of the European countries, then your playground is really the European Union in its whole. So that's a crucial point with the regulation. Basically, the regulation assures you that you have a EU passport, across the market.
Excellent.
Yeah. Just to say, just a very quick word about what happened in France right now, because of course the head of the French Central Bank have expressed his intent to accelerate the entry to force in MiCA, to have a mandatory license in France right now, before the entry to application of MiCA. It is just a word from the head of the French Central Bank. This institution have always been in favor of the regulation. Of course, it's absolutely natural. What happened right now, there is just some negotiation to accelerate for 12 months the license, the mandatory agreement, but only for the newcomers, actually. So it's just like a technical, it's just like organization with the French market authority. It's not really something very significant for all the actors that are currently registered with the IMF. So it's not really a big deal for the French crypto ecosystem in my view. And about the politics of France towards crypto assets. Yeah, I totally agree with you, Francesco. France have been since the Pact law in 2019, have always been to be in the forefront of the crypto regulation in Europe, both for internal aspect and external one. The main internal aspect is that Macron is pro-business and pro-innovation, and it have a huge impact within the French administration. And the other aspect, it's of course the Brexit. France, like Germany, willing to be the next financial place in Europe. I don't know if it's a success, but at least it have helped to accept the more and more virtual asset service provider in France.
Yeah, so it kind of stinks if you're a digital asset service provider in France and you're trying to get in before the implementation date of MiCA. So you have 18 months to now roll out all the different controls. But now all of a sudden, Jonathan.
No, precisely on this point, we're bound to see some movements happening from, let's say, a legislative perspective, I would say in most EU member states, due to the article under MiCA dealing with transitional measures, which is Article 123. Effectively, so there's the date of entry into force of MiCA, which is set to be hopefully sometime soon, as early as February next month. Then there's going to be the date of application, which is effectively when each different member state having to abide by MiCA, and you can offer services if you have a MiCA license. So date of entry into force, again, sometime in the next few months. Date of application for service providers, for instance, will be 18 months after that. Then there is what is known as the transitory period, which is 18 months over and above the date of application. So 18 months after the date of application. Now, member states potentially, depending on how you interpret this article, can only afford this additional 18 months of let's say, the so-called transitional period if they already have a national framework which is close to MiCA and which has been communicated to the European Commission and to ESMA and therefore approved by the European Commission and ESMA. So any member states which, let's say, have a framework which is not aligned with MiCA, or potentially they don't have a framework at all, and therefore they don't have national laws which are in line with MiCA, potentially they won't be able to afford any nationally regulated service providers this additional grace period of operating under MiCA without having the formal MiCA license in place. And that's quite a considerable benefit. And I'm sure that most EU member states would want to try and give this additional 18-month grace period to all their national service providers, because effectively we're talking, of course, about a whole new sector. And I'm sure that most EU member states will be rushing to try and get a lead in this new industry.
Great. Thanks for clarifying. So before we move on from just talking about the overall scope of MiCA, before we dive into some of the definitional aspects of how crypto assets, and we'll return to this in a later podcast episode, what about fully decentralized digital asset projects? How is that treated or not treated under MiCA?
If I may answer, so go ahead, Marina.
Yeah, thank you. So there is no definition of decentralization anywhere in MiCA or any other documents that I have seen until now in the EU, which might be a little bit different from what we have seen in the US, at least from like some guidance from the SEC. But what we have is there is a thing within what is within the scope is that the fully decentralized entities will fall outside of the scope of MiCA. And there is a specific part that says that just partially decentralized ones will not be excluded. And as Francesco said before, that's nice to know, but what does mean fully decentralized and what is partially decentralized? So this is also something that I hope we'll see over time, and we'll see how the national competent authorities are also going to interpret this decentralization in a way.
So just to add to what Marina rightfully said, the only hint we have in terms of what effectively constitutes full decentralization, which again, as we know, it is not really possible, as in what does full decentralization mean in practice, but the only hint we have is that effectively fully decentralized means without any intermediary, so effectively providing services without any intermediary. I'm sure there will be a discussion on what an intermediary constitutes. Potentially this may be supplemented through, let's say, technical guidelines that will be issued by the EBA and ESMA, but so far this is the only, let's say, hint that we have in Recital 12a of what effectively full decentralization may mean.
Could you say that if you can speak on behalf of a project and say we're definitively, and use the word we're definitively fully decentralized, you probably have a problem?
The thing is that there's simply, it depends, first of all, on what kind of metrics do you use to, let's say, measure decentralization. Is it from a network perspective? Is it from the developers, tokenomics, legal structure? So again, decentralization can wear various forms and shapes. And that's why effectively I would go as far as to say that full decentralization is a bit of a myth. And that's why there will definitely there will be a lot of discussions, and potentially will be the need of further guidance from the relevant European authorities on effectively what do they mean by this. And as I said, what do they exactly mean when providing services without any intermediaries? Is intermediaries in terms of legal entities? Isn't no intermediaries meaning that it's fully done in an automated manner using, say, smart contracts? We don't really know at this stage.
And do you think, just while we're on it, do you think there's any projects out there that would just naturally fall into the fully decentralized? I mean, obviously, like Bitcoin, nobody would say that's centralized. William, you're.
Yeah. No, but my answer would say I believe that it will not happen because for me this notion of fully decentralized have just been introduced within MiCA because the regulator is not deaf to the narrative of the decentralization, but we can easily understand that the full decentralization only apply to protocol. And the protocol will never apply to become CASP, or will never apply to something like to have a visa to be issued, or to be issued. So for me, it does not apply to application and projects, which are the entities that are subject to this text. So it's just in case of something happen, because the regulator is maybe not 100% sure about what happened in the crypto, but it will. Yeah, I'm not sure this notion will be useful for practitioner like us.
One has not to forget that like this indication of fully decentralization is in one of the recitals. So it's not like in the proper laws in the articles of MiCA, it's just in the recitals. And the recitals normally like only indicate political goals of the legislation. And I think that like the indication that we can get, and this is my personal take, is that basically the European Union didn't want to focus on DeFi. Like they know DeFi, we know it also from studies that were made at the level of European authorities. But the willingness was not to focus on decentralized finance, but to focus on in particular two topics, which are stable coins and crypto asset service providers. And I totally agree that basically what we can infer from this indication is the fact that like protocols and decentralized finance will not be treated as crypto asset service providers, because even if you then look into the provisions, you find out that there are a lot of difficulties in applying these provisions to decentralized finance. And hopefully, like the goal is like to, if in the future decentralized finance will be regulated, it will be done with a different instrument. This is a bit my take on this. And here I think it's interesting to make a comparison with the United States for the US listeners. The fact that like here, the focus is really on the crypto asset service for providers from the beginning. And I'm not aware about case law against like groups of decentralized finance projects. I know that there are also relevant projects in France. And I think that there is a kind of abstention from authorities in, let's say, intervening against these projects right now. And I don't see the MiCA to be like the instrument to break this, let's say, tolerance towards this kind of projects, because the focus is so specific on this kind of providers which are there and which will bring a lot of scrutiny and interventions and prudential regulations. And so my feeling is that the focus will not be on DeFi, at least for the next 2 years.
Excellent. So with that, let's start to talk about the definitions for crypto assets that we're going to be covering in our series here. So who wants to sort of lay out the categories? John, maybe lay out the categories and we'll start to break them down.
Sure. So in terms of, let's say, I guess one of the main reasons why MiCA was pushed forward at such an accelerated rate is precisely the definitions that, or rather the categories that have caused the most discussion, being stable coins that are effectively split into two separate categories. We have the asset reference tokens, and we have the electronic money tokens, or the e-money tokens in short. So I'll just be focusing briefly on these two definitions, and then effectively covering also the third category, being that of utility tokens. So the main difference between an asset reference token and an e-money token is that the latter is a crypto asset that maintains or purports to maintain a stable value by referencing the value of one official currency. So it has to be a token that refers to the value of just one official currency. And by official currency, it's an official currency that is issued by a central bank or other monetary authority. So it can be the euro, US dollar, GBP, etc. What matters is that it's just one currency is being referred to. Whereas an asset reference token is a type of crypto asset that, first of all, is not e-money. Secondly, maintains a stable value by referencing, and here I'm quoting the law, to any other value or right or combination thereof, including one or more official currencies. Now, so if there's, for example, a crypto asset which is referencing, say, the value of the US dollar and the value of gold as an example, that would be an asset reference token. Or if it's referencing the value of the euro and the Swiss franc, then it's also an asset reference token. Effectively, if it's referencing, let's say, the value of effectively an asset, another asset, or a commodity, then it stands a high chance of being classified as an asset referenced token. Now, before just mentioning one other point relating to these two particular tokens, we also have the third category of tokens, which is utility tokens. And this effectively is a crypto asset, which is only intended to provide access to a good or a service supplied by the issuer of that token. So we're talking specifically about access to a good or a service, and that needs to be supplied by the issuer of that same token. What's important to note is that, let's say, I would say, if we were to classify them in order of how strictly they are being regulated under MiCA, we have the utility token, which is on the lowest rung, I would say, where effectively in order to issue a utility token or to make an offer to the public for such a utility token, you just need to register to notify the white paper to the competent authority. Then you have asset reference tokens, where rather than just notifying the white paper, you actually need to have it approved by the competent authority. And then I would say at the highest possible rung, we have e-money tokens, where they can only be issued by a financial or credit institution. So this is by way of a brief overview of the category of tokens that are regulated under MiCA.
So to help our understanding here, let's take a Circle or a Tether. Would Circle or Tether fall into e-money or in an asset reference token?
I would say that under the current text of MiCA, the current draft text, they would definitely be e-money tokens.
Okay. And what about DAI, algorithmic stablecoins?
The thing is that here the focus is not so much on the method of stabilization, although this was part of the original draft MiCA text, but this was changed in future and the following iterations. What matters over here is whether the crypto asset itself purports to maintain stable value by referring to the value of one official currency. So the method used in order to refer to the value of one official currency doesn't really matter over here. Since DAI refers to the value of the US dollar, then potentially it would also be classified as an e-money token, which is quite interesting because here we're not talking about a token that's being issued in the same manner as USDT or USDC, namely by a centralized legal entity, but rather it's, of course, a crypto asset that has more decentralized routes and mechanisms. So it will be interesting to see how and if it will, let's say, actually be regulated, and what will be the repercussions and impact on algorithmic stablecoins like DAI.
Does anybody else have a view on algorithmic stablecoins? Because I know it's not 100% clear at this point. Anybody want to take some of the contrary views?
Oh yeah, 1 second. I think that the approach, even though it's not true, like the European Union wants to be technological neutral, and so the fact that it's algorithmic should not play a significant role, like in the classification of the tokens, at least according to the willingness of the EU legislator. But with respect to DAI, I think that another interesting point is, as it was mentioned, like the fact of decentralization. I think that we have like a use case to evaluate here. This recital, understand whether the fully decentralized character of the project could, in a case like this, avoid the classification under e-money tokens. And I think that there are arguments to argue this, because like if you take into consideration the rules which are framed for e-money tokens, they really hardly are can apply to a phenomenon like DAI and like MakerDAO. And so I think that there can be arguments to state that the fully decentralized clause can be applied here, or create an argument to state that they cannot fall under the scope of MiCA.
What I would just like to add to Francesco's comments is that the legislation mostly seeks to regulate either the issuance of asset reference tokens or EMI tokens, and by issuance meaning an offer to the public thereof, or otherwise when the issuer is seeking admission to trading of such crypto assets. So one would go as far as to consider, what if an issuer is not making an offering to the public, or otherwise is not seeking admission to trading of such crypto assets, being asset reference tokens or EMI tokens? Could they potentially, let's say, not have to worry about complying with certain provisions under the MiCA regulation? Again, this is subject, of course, to interpretation of the relevant provisions under MiCA, but there's also that consideration to keep in mind. Certain well-known stable coins like DAI, USDC, and USDT, potentially, if there are no active efforts to make further public offerings or seek admission to trading, may actually, let's say, be less impacted or not impacted at all by the relevant MiCA clauses.
Interesting. And let me just pull on the thread a little bit more on algorithmic stablecoins. I'll throw it to William, who also has another point. But let's say that we're not talking about DAI because they are referencing US dollars. Would the same answer apply? William?
Yes, I believe the intent of MiCA is to cover every kind of algorithm stablecoin. But I have actually a question for all of us, but maybe especially for you, Marina, as you are working at the Euro Crypto Initiative. Is that when I see MiCA for the first time, I was very surprised to see like two very different regulation like joined together. The one about the CASP, the crypto asset service provider, which makes sense actually. It's just the next step after all the local CASP regulation in Europe. And you have this big regulation with e-money token, asset reference token, and so on. And maybe tomorrow the e-euro, the future like central bank digital currency. And I still believe that it was maybe a political reaction to Libra. Or I don't know if you have something to tell about it, Marina, maybe at a higher level.
Yeah, thank you for this question. So maybe the first comment for the algorithmic stablecoins, we also have a comment in recitals in the 26th that mentions algorithmic stablecoins. And I would also like to add a comment in general. The whole process of the last 2 years of MiCA was also a result of what was happening in the market, in the industry. So algorithmic stablecoins were never mentioned before. What happened with Terra Luna? So now they are mentioned in MiCA. It was very similar what happened with NFTs. In the first draft that the commission issued, NFTs were not mentioned. Now they are. And maybe just a very general comment to your question. So of course, it was a reaction to Libra and to what happened at the time with potentially DM or Libra as a stablecoin. That would have a significant, I would say, impact and also a huge user base. And that's also one of the main goals for MiCA is to preserve financial stability in the European Union. And this is also why we can see this regulation when it comes to stablecoins, that in a way it wants to limit the use of stablecoins that would reference the foreign fiat currencies and its use within the EU. So also comments around DAI, I think that's very, very important, and it's going to be one of the most significant consequences of MiCA. Let's just imagine if DAI or some other stable coins would be maybe limited or different service providers would be limited from using DAI. I think that this is also something that we all still need to understand how it would happen, what it would happen. And I think that service providers here are going to have a really important role, mainly the exchanges. So the listing, to my opinion, is one of the most important elements and of course important thing within crypto. So what is going to be their decision? Even when talking to certain exchanges, I think that they have a certain opinion on different things related to MiCA, but their opinion has been not formalized, like I think formalized yet, of course, because we're still waiting for ESMA's guidance, as was mentioned before, regarding the difference between crypto assets and also the financial instruments, and of course the opinion from the national competent authorities.
Yes, I want to say something on this Libra DM story, because we have to remember that MiCA, like the first discussions were in 2019 with consultation papers, and at this stage, like Libra DM was a project that was heavily discussed. And you have to consider that the stable coins that now are very big, like USDC, Tether, were very small at the moment. And like to give you a bit the background, there is a kind of fight going on between the European Union and the big tech companies and the US companies. We saw this with the GDPR, like a lot of decisions are against Facebook and Google. And the idea of the GDPR was really like protecting the data of the Europeans against the exploitment of the American companies. I would not, and so the scope of application of the GDPR is very broad, and it encompasses all the activities that are made with data of the European customers. I would say that on the same like level of kind of trying to protect the stability of the European Union and the European customers, consumers, like there was the willingness of blocking directly this attempt by Facebook of creating their own currency, and this topic was very important. Like if you read the first articles written on the first version of MiCA, it was all framed, like presented as a kind of reaction against DM and Libra. Now this narrative is not so strong anymore, because obviously like the attempt of having the stablecoin now, like Silvergate wanted to buy the technology of Meta, but apparently it will not work anymore. And so like this is not a problem anymore. But in the meantime, like,
and they can't afford it anymore.
Yeah, exactly. But in the meanwhile, like Tether and USDC grow a lot, and they're not suffering too much from the bear market, because like the market cap is remained basically the same. There were also other stable coins that were growing from exchanges, for instance, the Binance one. And so now they're really seen as a kind of and the problem is that they're also pegged to the dollar, which is not so nice from a European perspective. And therefore, I think that now basically there are new arguments to try to avoid that the stable coins grow too much from a European political perspective, and therefore this is really something that will need to be seen, because the requirements that are set by MiCA are really rigorous and will be difficult to meet for Circle and for Tether.
Is it possible that some of these stable coins could be classified as asset reference tokens and not e-money?
That's a very good question, Eric. And we are at the forefront of a new type of regulation that is being born. And let me get a step back and get back to the algorithmic stablecoins, because at the end these are the next frontier. If you want, we are in the world of a new Bretton Woods. The underlying assets who are creating this new type of economies based on the digital assets. What I would like to mention from an e-money perspective, and here I'm trying to play a bit the devil's advocate, in terms of algorithmic stablecoins, one of the essential requirements for being qualified as e-money is you need to have a claim against the issuer. But algorithmic stablecoin is just a generic sort of qualification. You can have plenty, and there will be many ideas. It's like opening the Pandora box to what and how these algorithmic stablecoins will work. What are the baskets? what are the rules who are moving towards algorithmic stablecoins. So from this perspective, it will be interpreted from my perspective as a lawyer, on two sides. If it's really a claim against the issuer, each algorithmic stablecoin, by the way, it fluctuates and the specific rules. And the second one, let's not forget that the e-money directive does provide some exemptions, and it will depend a lot on how this stablecoin will be used. Because it's going to be fact specific of whether that stablecoin is used broadly, just to give you an example, or on a narrow channel used for specific purposes within, let's say, a DeFi ecosystem. So things are still moving. These are moving pieces. And we might not have all the answers, or some of the answers will be very much based on the specific facts.
Just to jump in on the point relating, for example, a claim against the issuer, etc. In one of the recitals under MiCA, the legislator clearly pointed out that under the e-money directive, these were treated as criteria which effectively lead to an asset or instrument being classified as electronic money. So therefore, in the past, and up until now, because MiCA is not yet, of course, applicable, if, for example, you issue a stable coin which is pegged to the US dollar, but effectively don't have a claim against the issuer, or rather the holder thereof does not have a claim against the issuer, then effectively that token cannot be classified as electronic money. And the legislator caught onto this and said, listen, we know about this, but this time round, we're not going to treat those as criteria which effectively have to be met in order for a token to be classified as electronic money, but rather if a token references the value of the US dollar or another official currency, it also has to abide by these other obligations, including you need to grant the holder a claim against the issuer, you need to make it redeemable against at par value, etc. So the legislator is now turning the tables on the status quo and effectively treating now those criteria as obligations that are imposed on any issuer which effectively issues a crypto asset that is pegged to an official currency. So again, this is something that I believe was a bit of an overreach by the legislator, because effectively it's almost going to impose certain perhaps hard to meet obligations on, say, issuers of algorithmic stablecoins. But this is precisely one of the reasons why, although MiCA, I think, overall is very well structured, there may have been a bit of an overreach by the regulator on for example, on stablecoins, and whether it was for due to the Libra or Diem incident, or whether because effectively, and we all know now that there's a Euro CBDC on the cards, and the European Central Bank has already been quite vocal on its stance again on anything which is not its own CBDC. And we also have, unfortunately, some members of the ECB board which are actively attacking crypto assets in general. But at least now we know what the agenda is. We know that effectively that they're paving the way for Euro CBDC, and that anything which is not Euro CBDC should be subject to the strictest level of regulation possible.
And so when we talk about the referencing to a single currency, to the extent like a stable coin has a basket of government treasuries, and not precisely the currency per se, but treasuries that could be convertible into, does that change the application of the definition at all? You're on mute.
In that case, if it's referencing to a basket of currencies, then it would be potentially treated as an asset reference token. Must not, let's say, effectively mix the fact that the token refers to a value of an official currency and effectively what constitutes the reserves. And incidentally, currently, I would say under the laws, and again, it's a generic statement because we're talking about e-money directive, but most EU member states would only treat a particular asset as e-money if in the reserves you're keeping a 1:1 backing or reserve of what that particular token actually represents. So in fact, say in the case of a stablecoin, which has, let's say, reserves that are made up of treasury bills and securities, etc., then the mere fact that the reserves are constituted of different kinds of assets would potentially lead to that particular token not being classified as electronic money under the current e-money directive. Once again, this is something that MiCA seeks to address, in that if the focus is on effectively, if the crypto asset refers to the value of an official currency, then stop whatever you're doing. It's an e-money token, and you need to abide by this list of obligations. No questions asked, unless, of course, you found one of the exceptions, but this is what you need to do, otherwise you're going to be in trouble. And that is the intention of the legislator, in that it seeks to effectively eradicate these kind of loopholes that have up until now, and let various companies issuing crypto assets that effectively, of course, refer to the value of official currencies, so-called stable coins.
Francisco.
Yes, I wanted to say, I think that the elephant in the room in this legislation is the e-money, the directive, electronic money directive, and there was the willingness of creating a kind of parallel with this, like without impacting the already existent European law. And so they created this correspondence with some additional requirements for electronic money, which is issued in tokens. And therefore, they didn't want basically to avoid the application of what was already established at a European level, and they added some additional requirements, and this will be very impactful on stablecoins. And I want to say that it's very enigmatic, understand when asset reference tokens will be really applied and when you can qualify an asset reference token. My feeling is that all the stable coins that we know that were mentioned before will fall under the definition of electronic money tokens. And I want also to indicate, because it's interesting, the FINMA, the authority in Switzerland, elaborated some guidelines concerning stablecoins in 2019, and you can see that the regulatory technique was completely different. There is one umbrella for all the types of stablecoins, and then depending on the way in which you create the reserves, you apply a different regime. For instance, if you invest the money that back the stablecoin, then you apply the rules on investment funds. If you work as a bank, then you apply the rule on financial intermediaries. And I think that this was a very clear approach, and a very, I would say, rational approach, because depending on the way in which you treat the reserves. And I also saw that your question was proper, but if I invest the money like what I am, and I think I agree with Jonathan, you are on electronic money tokens because you have the duty of respecting certain thresholds of reserves, and the rest can be used in a different way. But I think that's the way of addressing the issue by the Swiss legislator, very simple and very clear, makes more sense at this level. But we will see, of course. So I have problem, for instance, in indicating what exactly an asset reference tokens will be, to be honest.
Yeah, and so I guess that's sort of the next question. I think we have a clear. We've talked a fair amount about e-money, and it's such a critical classification. What do we think naturally falls into asset reference token before we start talking about utility tokens?
So you want to go ahead, Francesco, or?
No, go ahead, and then.
So I think there are some examples of stable coins out there, which, for instance, refer to a form of NAV. And case in point being the RAI stable coin. In my opinion, that would be a clear example of what could potentially constitute an asset reference token, since it does purport to maintain a stable value by referencing to a right or value, as the definition of ART states. And if my memory serves me well, effectively RAI maintains stable value by referencing to the basket of assets that's being held in its reserve. So effectively, it is referencing to a right or value, and its price, its value has relatively remained stable at somewhere around $2.80. So that could be an example of an ART. Now, what's also interesting is that throughout various parts of MiCA, there has been not the mention of a right or value, but at times there has been specific mention of assets. And in the previous version of MiCA, there was an outright reference to just commodities. So one would ask what the intention of the legislator is. Is it basically trying to define ARTs as a catch-all category, that if effectively you are trying to keep an asset at a particular price, then effectively it's going to potentially be seen as an ART? Or is it just using the term right or value to widen a bit the scope of commodities, but basically effectively leading the reader to think that the reference needs to be to a commodity or something which is similar to a commodity? Again, this is potentially subject to interpretation. I would find it rather hard to digest that effectively they're trying to treat ARTs as a catch-all definition, because that would also be quite worrying, as it would potentially stifle innovation. And for example, last year, we were close to seeing the full-on emergence of protocol-issued stablecoins, which I was actually looking quite forward to. And if the definition of ART is intended to be as wide as possible, then it can potentially lead to, let's say, such protocols going back to the drawing board and seeing whether they can come up with something which would not fall under the definition of ART or EMT. Again, it would need to be something that does not reference its value to any right or any other value, which I find it quite difficult.
Right. And it's one thing that's the distinction for an ART versus like an e-money token or utility token is an ART actually has limitations imposed on it under MiCA, correct?
There are really enormous requirements to the issuance, also concerning the type of organization that can issue the token. It must be in the European Union. There are really a lot of additional requirements that have to be met. Whereas, as was said before by Jonathan, like the utility tokens is the lowest level of compliance that exists. And in MiCA, it's even less than MiFID, because the willingness was like to create a category which is, let's say, there for innovation. And whereas like asset reference tokens is something which where you see like the angry face of the European legislator that wanted to regulate it very, very strictly. And so, yes, I see the point of Jonathan, and I think that there must be the effort of trying to clarify exactly which cases fall under asset reference tokens, because it does not become like a catch-all definition. And I think there isn't the willingness of doing so. Like I was reading to prepare the meeting, also the recitals concerning the different categories of tokens, and they make clear that there are three categories basically. One are the tokens that are financial instruments. Then we have asset reference tokens and e-money tokens, and then there is this third category which is made by utility tokens and every other token in the world. And therefore, I think this is the catch-all category. It is a residual category in which you don't apply the previous two, and it's composed by utility and something else that needs to be clarified. And I think that like we're going to discuss about it, and having this positive box, I would call it like this, like a box where you can fit, when you can put tokens, is something which will be of paramount importance for the regulatory future of the European Union, because it's something which we don't have, at least like it's not clearly stated at a US level. And that's the big difference, in my opinion. Like the fact that we recognize the existence of these tokens that do not fall into this category is very important. And we have to wait the guidelines, but we have also to front run a bit and to indicate a narrative which brings us to recognize which are these tokens that do not fall into the other categories.
Great. So, John.
I just wanted to also add that there was also the questionable limit being imposed on asset reference token issuers in the case of the use of the ART in question, to the point where it's used as a means of exchange, and there's more than 1 million transactions taking place, or otherwise the transactions total more than 200 million euro being transacted. So over here, the legislator is saying that if it's being used in such a manner, or therefore exceeding these particular thresholds, then the issuer has to stop issuing the ART altogether, and has to present a plan in how it can curb its use so that it stays below the mentioned thresholds, which of course then leads to the discussion on what effectively constitutes a means of exchange, and when does an ART transition from being used as a means of exchange to a means of payment. So again, there's a lot of questions being raised on this point as well.
I'm not entirely sure how an asset reference token could be decentralized, but that could be like, if it was something that was achievable, that could be a potential off-ramp. As you're starting to hit that threshold, you really start to double down on decentralization, because who wants to reach that stopping
point? Yes, I would say that first of all, in terms of, let's say, the point relating to decentralization, I think there's going to be a lot more importance being given to those structuring this kind of projects on effectively how to become, I would say, decentralized to a point where you don't have to worry about meeting these kind of, I'll almost go to say, not reasonable obligations that are being imposed on the issuers of such kind of crypto assets. Secondly, as well, it's just very clear that once again the intention of the legislator seems to be limiting the use of these kind of assets as a means of exchange, which then of course begs the question, okay, then how do we ensure that such tokens are only used as a means of payment? I mean, if you are, let's say, semi-decentralized or trying to go to become as decentralized as possible, then it's a bit at odds in terms of trying to limit its particular use, because the more decentralized you become, the more it is difficult to effectively control and manage what the token in question is being used for. So are we talking about something that is sort of like at odds to abide by? Again, all these questions are being raised, and the more that one reads throughout MiCA, because I feel that there has been a bit of a knee-jerk reaction from the legislator when it comes to stable coins, and now we are seeing the extent of this knee-jerk reaction through these kind of measures that have been, some of which have been introduced at the very last minute, and it's clear that some of them have been written in quite a rushed manner.
Right. All right. So with that, I think we'll jump into utility tokens, which I think is sort of that certainly from an American perspective, much more exciting to be in Europe than in the U.S. Francesco, do you want to take that one to start off anyway?
Yes, apparently it's very exciting, and so like this approach of trying to subdivide tokens in different categories exists, of course, at a technical level. Like, we distinguish between the different functionalities of the tokens, but here, like, we have brought it, like the European Union has brought it at a different level in trying to distinguish also from a legal point of view different categories of tokens. This approach is not new. Like, also in Switzerland, it was adopted since this guidelines of FINMA of 2018, and the United States was always aware of the fact that there are countries that try to distinguish between the different functions of tokens, and basically the most important element is the fact that you don't apply the rules concerning financial instruments, and so in Europe the rules of MiFID to tokens which are not considered financial instruments. And as I said before, in MiCA we have these third categories, which are utility tokens, and then like a residual all crypto assets that do not enter into these categories that are defined. And so I would start from the definition of utility token, which are tokens that basically give access to a service or a good. The definition indicates that like the only function of the token must be to access the service or the good. And this, of course, is not so fantastic news, because even though it's not clearly indicated in MiCA, one of the problems will be to assess like what happens if the token has a utility, but at the same time presents elements that belong to a category of financial instruments. So the mixed nature of the token. And for instance, like the Swiss authority FINMA indicates that in this case, the token falls under the regulation, the securities regulation. The European Union does not do it in a precise way, like there isn't an express provision that tells this, but nonetheless, the fact that there is the indication that the token must only provide access to a service may bring you to the conclusion that it must be really like the dominant function, at least of the tokens. And so also here we can make the exercise: what is a utility token, what is not a utility token? And I think that like all the layer ones, which provide for coins that are used to pay for transactions, have a strong argument to basically say that there are utility tokens. But it's very difficult to address like many other cases in which you have a utility, for instance, accessing to a given platform, or also providing like governance. What is governance? Because it is something which recalls a bit the shares of a company, which brings you more in the direction of a financial instrument. At the same time, it is something which let you belong to a certain community. It could be seen as a kind of service. And so I think that's the thing to understand, will really to make a separation between these two categories, and the only basically category that can be used as the utility token to say that it will not be a financial instrument. And so I would say that layer ones, if there isn't like really a willingness to push so much on the price and declarations, and it's just there in order to provide the function of paying transactions, I would say that there could be considered utility tokens. Another example that is made that we can discuss is the example of Filecoin. This is always used in the articles that address these issues, because you clearly have a service which is provided. And so like I think that this will be the element to evaluate if the MiCA is a friendly regulation towards crypto or not. Because if we take this definition and we interpret them in a strict way, then this category of utility tokens will be very, very small. And in the end, there will not be such an enormous difference with respect to what happens in the United States. If we arrive, there is an effort in the guidelines to make clear that utility tokens is a broad category, then we will have more room for innovation in this. Because as it was already said, like the categorization as a utility token gives you the possibility of applying a regime which is not so strict, like the regime in which you can offer a token to the public through a white paper, which will not be like an impossible requirement to meet. And therefore, like this is really one of the central points that we are going to address. I'm happy to speak more, but I want also to hear the others, of course.
Just wanted to point out that there may be a bit of a problem coming up in terms of, let's say, token issuers who would like to be in the clear when it comes to the classification of the token under, let's say, EU laws and under US laws. Because in order for them to be classified as a utility token, potentially they would have to forego ever, let's say, not satisfying the how test, because if the issuer provides a good or service, then effectively it greatly diminishes the chance for the token issuer not to satisfy the fourth prong of the how test, being the managerial efforts of others. So we could potentially come up to a situation where the issuer of a token has to, let's say, for lack of a better word, pick their poison. Would they want to be in satisfaction of the definition of utility token under MiCA, but then potentially, of course, have their token never being potentially classified as a non-security for the purpose of US laws? Or would they effectively go around in terms of issuing a token as a non-security under US laws, but then potentially, let's say, they would have no clarity as to there would be the applicability of the MiCA regime in their instance? Because if the issuer is not providing a good or a service, then you can't really argue that the token will be classified as a utility token. Would that mean that the token falls outside the purview of MiCA? Potentially. But again, it seems that if one takes a restrictive interpretation of the definition of the utility token, then as Francesco said, there's only going to be a small set of tokens that would, let's say, be in full satisfaction of this definition. And therefore, the question is, what happens to all those other kinds of tokens? Case in point, governance tokens. does a governance token really grant you access to a good or a service? Well, I would say depending on the governance token and the rights being granted, potentially not. So I would say that there's still a good chunk of crypto assets which could potentially not fall under one of the three categories being listed under the MiCA regulation.
Maybe one thing that I want to mention, and it's really concerning all the issuance of all the different types of tokens, is that, as Francesco said, when especially the Commission was thinking about MiCA, it was 2018-19, and that is when ICOs were still fresh. And so basically one of the only ways how projects were issuing tokens was all at once. So we had a bunch of tokens that were issued at once, similarly as we know from the just general exchanges with stock markets. So what the problem might be with different projects, and we can talk about DAI and some other projects, is when the issuance is not happening all at once. And so the obligation that we have for writing white paper might not be possible to be, I would say, observed, because sometimes it might happen that first the tokens are not issued all at once. They might be even issued, or the user might be the one triggering the creation of a new token or the issuance of a new token, and that making it impossible for them to basically issue a white paper at the same time, or even talk to the national competent authority to address this time frame of the issuance of the tokens. So I'm not really sure how that is going to be addressed. I'm opening also the floor for the questions here if somebody has different ideas, but I think that that might be also one of the main limitations, just because, yes, MiCA was designed at that time, again, having in mind stablecoins that we knew from that time, but also the way how different crypto assets were issued at that time.
Yeah, Marina, your question is very interesting. I obviously don't have the answer, but I can just talk about what I have experienced in France for the last 2 years, because France have created like a dedicated regime for ICO and token issuance, and a definition of token which is not so far from the definition in MiCA. And actually, I feel quite comfortable with the definition provided by MiCA, being understood that it's subsidiary from the definition of financial instrument, of course. But in France, yeah, so they created this ICO like framework. It was optional, so you were not supposed to get this visa to do your ICO, but it was of course recommended and encouraged by the regulators. But actually, it was a huge fail, because exactly for what you were talking about, like the era of like the one-shot ICO, like kind of IPO with token, it's not so popular right now. Most of the token issuance we see, it's I don't know, you have a game and the user can mint a token in the game, or can buy a token within a game or within a services. So all these like rules defined to protect the investors. For instance, in France, when you ask for the ICO visa, you need the issuer need to put all the cryptocurrency, all the funds into an escrow during the token sale. The token sale is not supposed to last for more than 3 or 6 months. There is a lot of rules that make sense if you are issuing if you are doing one issuance, but that's not appropriate at all if you are like just using and issuing a token within the services. So maybe we will have the same problem with the MiCA regulation, depending, of course, of the interpretation of the rules.
Can I say one element?
Muted. Sorry.
Oh, I'm sorry. Yeah, one element which is interesting, and I don't know if it was like this also, or if it is like this also in France, is the fact that, like, I totally agree with what you say concerning like the ICO era is terminated, and nobody wants really to have another one. But like an interesting point here is that you don't need an authorization to issue the token, which is because you have to notify the fact that you are offering the token to the public. and so like basically sending a letter to the authority, but you don't need to have a prior authorization. And this was made because they thought that it was like too much for the authorities. And in fact, what we see also, like Switzerland, which is very fast, but it takes like 6 months in order to have a no action letter that basically clarifies that your tokens is not a security. And so this is something which is nice. I think it is not of interest for very big projects, but like some real estate tokenization stuff like this, I think that you can have a clear utility, and it will be nice like to have a small fundraise in this way. I think that there can be a kind of new utility that will spring out of these provisions. And so I wouldn't say like, of course, like the expectations were different when MiCA was presented, but nonetheless it's interesting. And then my other point, and perhaps like I'm too optimistic, but here I want also to hear our host, like the fact of presenting this category could be important like at a global level, because you really indicate something which exists from a region which is important for the crypto industry, and therefore like the fact that utility tokens exist make all things easier also when you are, I don't know, preparing soft agreements and stuff like this. And so the recognition of this category can perhaps influence also our US friends in the direction of recognizing a category which are not of tokens which are not securities.
Yeah, one thing that I find interesting about this category is the way that the room for interpretation can have such a significant impact, right? So to the extent that it encompasses more of these projects and has those requisite standards, then that is going to happen. It is going to be more of a magnet for innovation. Europe is going to be seen as leading the world. If it's interpreted narrowly or there's a lack of clarity, I know you were mentioning like an L1 for a utility token, but in a lot of cases, an L1 might also just simply might fall out of MiCA just because of their decentralized nature. And I would guess, and maybe others have a different view, that even Filecoin might not fall within MiCA as well. So it might be a more of a subset of not fully decentralized projects that also meet that fall within the utility standard.
I think that's very interesting. And if we think that there will be a category, let's say Filecoin, Bitcoin and similar, that would be decentralized enough to be excluded from MiCA, then we still need to think about the listing action. And there's also a description. I know we'll talk about this in the next episodes, but there is an idea if the issuer is not writing or they're not issuing a white paper, then, for example, an exchange would need to write that white paper in the name of the issuer if they would want to still list that tokens on their own exchanges. And I think that poses a ton of questions. I think it's going to be very, very interesting to see how this is going to be evolving in the future. And of course, I think thinking again about, in a way, the plan's responsibility, but also the thoughts around the biggest crypto as a service providers versus also all this guidance that we're waiting from ESMA, EBA, and also, again, the national competent authorities that in some cases will need to be notified as it was said before, what Francesco said, or even they would need to issue a license.
If I may, Eric, for me, and I would like to go to Francesco and John with this one, but for me, one of the expectations in terms of guidance is in relation to utility tokens and the word future. Either utility tokens, they will provide you future access to services or goods, or is it, various, we can create various interpretations, or access to future goods or future services, because this will affect a lot the industry in terms of issuances, as we discussed. This will affect the way SAFTs will be built or structured in terms of if we do it in Europe. This will affect the way ICOs will be created. either partial ICOs. The way we, and in this respect, I'm making a parenthesis on the white paper requirements that we will be discussing, in our future episodes. But for example, the white paper says that you are not allowed to discuss to create assumptions on the future price of the tokens, for example. So this relationship with the word future, for me, it's very important in order to how to structure an issuance. This might take us also in a clearer light than what we see in the world of securities in the US, with the reasonable expectation of future profits. So a lot will be in the realm of what's happening next once you issue the tokens. And for that, while we have a broad interpretation of the utility tokens, specific points based on guidance will be needed.
Just a point related, because we mentioned Bitcoin and let's say, for example, Ether, etc. The legislator under Recital 14b categorically states that crypto assets that are offered for free or that are automatically created as a reward for the maintenance of the DLT or validation of transactions are excluded from MiCA. So, for instance, Bitcoin clearly then would fall outside the scope of MiCA, and any other coin which, let's say, is effectively distributed to those assisting or providing services for the validation of transactions, such kind of issuers and such kind of assets would be excluded from the scope of MiCA. So just wanted to make that point in order, of course, to let's say clarify that point relating to such kind of crypto assets.
Yeah, that's a great point. I made the example of layer one just to make an example of something which has utility, imagining that there will be another layer one with an offering in Europe or something like this. I wanted to tell also something about the regulation more in general, not about the white paper that will be discussed in the next episode, but there are some elements which may appear strange. I think that this first part of MiCA resembles a lot like the technique that normally is used by the European Union to regulate consumer law. You have a lot of information duties which should help the consumer to understand what it's doing and which are the risks involved. And actually, to be honest, that's not so bad, because what we've seen in the ICO area was the fact that you had almost always this white papers or light papers which were very different one from each other. Sometimes they were jokes, sometimes they were well made or only with technical informations which were non-understandable by consumers. And we will have with this regulation basically an indication of what needs exactly to be put within the white paper. And also here we have the indication that ESMA will provide technical guidance as to how to draft the white papers. And I think that this standardization will be very useful for the industry, because if there is a project which is serious, which in any case wants to have a white paper, I think that this will be a nice model to adopt and also will give a bit of certainty to the project of doing things in a proper way, because it resembles what is required by the European law in a way which is in this case precise, I would say.
Maybe just a comment on this. I see that Francesco just mentioned the technical part. So we discussed this before, but the markets in crypto assets regulation is now going to be voted on. And of course, the secondary part, the technical part, technical process starts, which means that mainly the agencies, ESMA and EBA, are going to work on those technical standards. So basically defining the ways and the information that different crypto asset service providers or issuers are going to need to basically send to the national competent authorities, or in some instances, the agencies. And as you said, this is going to be a very important part on really technically what needs to be sent there and what is important for evaluating this project. And of course, that's also a process that we are going to be a part of, and I think it's going to be quite significant. We've seen this process being already finalized for another quite important document, the DLT pilot regime, that has already been finalized in Europe. And we see that in a way, again, this is important for everyone that will go through this process in the future.
And one thing that Francesco mentioned is could be very also important for the U.S. is when the standards are being developed for the white paper, the disclosures that could also end up being an opportunity for U.S. and European regulators to actually, I guess, draw from each other's statute or legislation to the extent, or guidance to the extent that they start to formulate guidance around disclosures that make sense, right? So in the US, one of the biggest problems with securities registration is the types of disclosures that are required just aren't fitting for digital assets. And they can force the imposition of structures that aren't aligned with the project and actually fail to incorporate certain things that are critical about a project while over-including other ones that are more appropriate for a more traditional company. So perhaps the white paper, and I guess we'll end up talking more about the white paper later, but particularly as it relates to ongoing disclosures and ongoing updates, I think that's something where certainly the U.S. regulators, I think, are starting to grapple with. Right now they're probably focusing more on trying to stamp out crypto altogether, it seems like. But I think ultimately, the disclosure component of it is an area which has a lot of acknowledged difficulty by the regulator in terms of applicability, and it's something that they've stated that they are looking to try to figure out. But we'll see what that effort actually produces, particularly in a post FTX and now DCG likely implosion era.
But just about this, Eric, I think creating a brand new legal framework like MiCA and like the VASP. Every VASP regulation in Europe, except in Germany, which is the Germany is very interesting because they have taken another path. We will all land at the same in MiCA, but they have chosen to assimilate crypto asset to financial instrument. Is that it gives you like the opportunity to creating a requirement in the white papers that fit with what you can do and what you can do with the token. I know that I think in Switzerland they have some guidelines about what should be mentioned in the white paper if you are doing an ICO. In France, there is also guidelines to the disclosing what you need to disclose in your white paper if you want to fall within the scope of the French Market Authority visa. And it's not perfect, of course, but it makes sense. It's not something like, it's not a copy paste from what you expect from a financial instrument issuance.
Excellent. So I think as we start to close out for this discussions, the classification of crypto assets under MiCA, and we'll certainly be opening it up again with future episodes. I wanted to just sort of touch on, and I think we referenced it a lot already, but I wanted to touch on the distinction between what MiCA proposes and the state of play in the U.S. In the U.S., you have the SEC. In many cases, you have like a chairman who sort of just asserted a view and almost unilaterally imposed an interpretation on the entire country, right? And it really seems to be driven by potentially some members in Congress who aren't always as educated, or maybe more aligned with a CFTC or an SEC in how they view these things. Whereas in Europe, maybe just talk a little bit about the forces that sort of allowed these definitions to take effect, because it seems like it's been sort of a more thoughtful, organized process to create this legislation, and there's much more consensus And whereas in the U.S., we have certain bills. We have the Louis Gillibrand bill, which is very well thought through. We had the Stabenow bill. Apparently, Stabenow is now not seeking re-election. So I guess that suggests that it's may not have as much weight. I think it was losing weight anyway, but the processes are very different. And I just would like to get your thoughts on how you view the processes as having influenced where MiCA ended up versus where the U.S. is struggling with now.
If I may start, I think first the differences between the U.S. being a common law basically space versus what is happening in the EU. And I'm really, really happy we have the opportunity to talk about the EU regulation here in this podcast, because I feel that in general, there's not enough maybe discussion around what's happening in the EU and how the EU functions. So the Commission basically usually that's the whole process and the kind of political agenda on what it wants to regulate in the 4 years when it has the mandate. And within those 4 years, the Commission issued the first draft of MiCA, which then goes to the European Parliament that issues their own draft, and then the Council issues its own draft. The Council is usually composed by different member states. So everyone in a way in the EU has its own place to give feedback and to address their own interests. And this is how it happened with MiCA. And in a way, it was something that started in 2019 already. So it takes a lot of time, but we also have a kind of a predictability that might not happen right now in the US. So when we first saw the first draft in 2020, we already had kind of an idea of where it will go. And then it changed, of course, in the next 2 years, but the main ideas remain the same. And now, if you think about it, if you are a startup or a company, 4 years in advance, ideally, what will happen and how you will need to think about maybe being compliant in 2024 when MiCA will be applicable. So I think this is one of the first differences. And the others is, of course, the discussion right now between the SEC so the tokens mainly, I would say, being the securities or being commodities. I think this is now very clear with the EU, which tokens are going to be securities or financial instruments and which are the ones that are going to be crypto assets. And maybe another thing that is very important right now, and I think it is also a very positive thing coming out of MiCA, is that DeFi is not yet regulated under MiCA. So we still have some time. The Commission has commissioned a research that was written about DeFi, so decentralized applications. And in this research, we have seen also very positive aspects saying DeFi is different than centralized entities, so it would need to be regulated in a different way. And I know that some of our colleagues in the US were very much looking into this report and taking some ideas from it when they are also arguing in the US how the new crypto asset regulation should be in a way drafted. That's briefly.
To also add to what Marina said, I think one of the main issues in the US is that, first of all, there's no clear leader in who is establishing the strategy and the roadmap for crypto regulation. And therefore, there are all sorts of mixed messages being sent out. Case in point, and the current SEC chairman, Gary Gensler, went completely back on the previous statements of William Hinman on what effectively could potentially fall outside the scope of the Howard test in terms of sufficiently decentralized projects. And this is something that, for example, we almost risked in Malta up until 2017 when we were discussing crypto regulation. And it was only when the administration at the time decided to effectively take control on all the efforts that were and discussions taking place in trying to enact a crypto regulatory framework, appointed a team of persons to take the lead on this. And then what emerged effectively is the first framework of its kind in the European Union, which to this very day remains the closest national framework there is to MiCA, since it was modeled off the MiFID directive. It was only possible because there was, let's say, a champion of sorts which emerged and said, listen, forget what everyone else is discussing, forget what the various authorities are saying about themselves. this is what's going to happen, either follow this or just step out of line. It's a bit perhaps of an autocratic approach, but when trying to regulate on something as innovative and as divisive as crypto, you need to have a clear strategy. You need to have a clear road that you want to pursue. Otherwise, it's going to be effectively a case of too many cooks spoiling the broth.
If I may, Eric, fully agree with my colleagues. In relation to the US versus European Union, it has been, part of the fiber of the legal and politics of the country that regulation by enforcement is more common to the US than to Europe. And in this respect, Europe has taken, best practices from the DOJ, for example, in the antitrust. So regulation by enforcement in the US has been, critical in addressing market failures in various aspects of the US economy and society. While on the EU side, we've been more, code civil driven. We are more onto the statutes rather than, and we want the law rather than case law will help us or guide us in the way we are going to regulate and legislate for the future. So in this respect, that's the critical difference. The problem is that crypto and crypto assets and virtual assets are not a market failure. This is a new economy. So for that, you need, as Jonathan was mentioning, you need, sort of a strategy for the long run, which cannot be done by short-term or mid-term type of agency strategies, but you need a sort of a legislature type of approach as being, the ultimate goal in regulating and legislating an area of society. My 2 cents on the topic. And last point. It has been coined by Professor Ann Bradford from Columbia, who's an eminent professional in the antitrust space. But the concept that we are discussing now, if you want, is so-called the Brussels effect. And we've seen it in other areas, and I think that MiCA will have the same impact. Basically, whenever EU managed to innovate in the area, like the GDPR, or the sustainable or energy sustainable goals in the past, you could see the spillovers of this type of regulations across the world. And, Professor Bradford at some point provides an example. For example, when European Union decided to impose stricter regulations on the filters of the cars, and how it filters the diesel and the oil, you could see this spillover effect in the car manufacturers from California to Asia. So this is the Brussels effect, and we hope to have this same type of effect also in the space of virtual assets.
Francisco?
Yes, I also want to comment on this and continuing a bit the discussion of Alex concerning the regulation by enforcement. I was quite astonished to see it in the last 2 years in the United States. I think that this kind of interventions without having a clear framework are not possible in the EU. I think that the approach is different. I think that there was also like a slowdown, as I've said before, because everyone was waiting a bit for MiCA, and so like also the authorities, for instance, the one in my country, we invited one time the commissioner at the University of Consop, and I was astonished like how much he knew about rug pulls and all the stuff which is going on in DeFi, but nonetheless there was not the willingness to intervene because like they were waiting for MiCA. He was just a bit disappointed, I can tell you, about the fact that he clearly stated that MiCA does not encompass DeFi. I was happy about it. I didn't show it in this moment, but like he was saying, it will not cover all these situations which are so dangerous, etc. On the same time, I have to say that some actions which were provided in the US against very perhaps weak projects as the WikiDAO and library. I didn't like this kind of intervention because I had the feeling that they wanted basically to create a kind of signaling function in going against very weak projects to create a kind of case. And I think this is not the way of regulating in a field which is very unclear from a technical point of view and also from a legal standpoint. And therefore, I think that this regulation by enforcement for technology is not something which really works so well, because we are in a phase in which like there are experiments concerning the technology, and so it is something which is very harmful. You don't do nothing, or you create a framework which is credible. You don't like basically impact so hardly on the technology without having a framework. And then the other thing that I find really different in the US is related also to the activity of the lawyers. Given the fact that class actions are so widespread in the US, and that there is also the willingness of law firms of investing into cases, it is something which I think it's growing a bit in the EU now. We have also like financial intermediaries that pay for big cases, but it's something which is very at the beginning. But like reading a claim like the one that was made against Compound, like a class action in which the class is made by 3 people that lost like $1.50. It's something which really is astonishing for a European person, and I would say that like a European lawyer would not invest in this kind of claims, and this creates an atmosphere in the US which really brings on the one side to have fear and like to avoid to begin something in the US, and on the other side it brings like for people that have the means to do it because they raised money also to an over compliance of things that nobody knows if are really required, but it's really inefficient to address things in this way. And so I think that in this case, like it's a case in which you need some guidelines because the technology is completely new and you cannot really apply the same rules that you had until now. And so like in this way, I think that MiCA presents a lot of similarities to already existing rules, but I love the fact that it is a brand new instrument that was made for a brand new technology.
Right. And to that point, Francisco, when you have a regulation by enforcement regime, it does sort of signal an open season to class action lawyers, right? Because you get, a hostility out of the federal regulators, you got potentially hostility out of state regulators, and it really just seems like, like in WikiDAO, like it just opens up a whole new avenue. Like, oh, if they're going to do it, or I can bootstrap off of these claims that they made in like the Wahi case, even though those projects weren't even like directly, the action wasn't directly against those projects. They didn't really have the opportunity to defend themselves, but yet, you're making law by association or some indirect means. It does sort of give rise to that environment where it is open season. And I do think we're entering into open season on crypto more so in the US, unless something is more sensible is done, and it is going to definitely impact U.S. long term. But I'm going off on my own. I haven't asked William for his thoughts on it before we close out this episode.
I will not repeat because everything has been said by my dear colleague. But my last thought was about this difference of way to regulate between the US and the EU. The US have a very strong way to regulate by enforcement, both from the regulators and from lawyers in class action, which is, as Francesco outlined, is absolutely impossible and unbelievable in most of the EU on the EU country. But in the other way, I still thinking that the EU have, with MiCA and especially with the stablecoin and utility token part of MiCA, we have been very far in the detail and the way to try to regulate as much as possible as we can. Europe is trying to giving a comprehensive framework of stablecoin without having any significant stablecoin issuer. So it's very interesting to see this huge difference of approach between EU. We're trying to have like a kind of GDPR for the crypto, and it's sometimes too much. I mean, very complex discussion about what like asset reference token is or is not is one example of this complexity. And I sometimes regret that in Europe it's very complicated for investors to obtain like the sanction of bad actors, and sometimes the regulators, at least the French regulators that I know quite well now, are very very prudent, sometimes very quiet, and sometimes we would like to have a sheriff in town, but I mean, it's just my opinion.
All right. Well, with that, I want to thank everybody for their participation in this episode. We'll be doing more of these. So, and I'm excited with the way it happened, the way the discussion went today. So, thanks so much for joining.